Well, that would be intellectually correct. Steyn IP. So what's with the waistcoat? Let me tell you what's with the waistcoat. So I like looking corporate and I like looking professional, and it's good for us in our cumulative roles to look decent. And so the question is, do you wear a tie? No. Right? And many years ago, I was like, I don't want to wear a tie because a tie is just horrible and it's restrictive and it's terrible. Exactly. So I thought to myself, okay, what can I do that's a little bit different? What can I do that can create something that, because again, a pair of pants with a shirt looks very normal. So yeah, that'll learn you. So many years ago, I was like, waistcoats, and I love waistcoats.
Yeah,
I love the way
awesome.
waistcoats look, and I love them. And so I went out and bought a shit ton of waistcoats, and I like to mix and match waistcoats with different types of, and now it's become my thing. In fact, the fact that I'm sitting here without a suit jacket is quite a big thing. Obviously, you don't want to, but that's my jam, man. It's jeans and a waistcoat and shirts.
But that's awesome. I also have a bunch of waistcoats, but something just this morning told me not to wear one.
Don't wear one.
And I know
the exact same one.
Yeah, the exact same
That
one.
would have
I've
been
got the
so
exact same one.
That would have been
And
so
I'm like,
awkward.
well, it wouldn't. It would be like,
Cheech and
oh,
Chong.
that would be really cool. It looks like we have a costume for the talk. But no, but that's quite cool. I got into waistcoats because I found one in my grandfather's closet. I'm like, oh, this is cool.
Old school
one. And I was a kid, and I'm like, this is cool. Why don't more people wear this?
Yeah, I love it. I love it. And everybody and so it's called kind of, I guess, part and parcel of creating my own personal professional brand. People know me like this now, and when I'm not like this, they're like, well, what's wrong? You know, why aren't you suited up? You know, and so in my game, and what's interesting is many people say to me, you look like a consultant. I'm like, what does a consultant look like? And they're like, you look like a consultant, but I'm also a trainer, so it's a bit awkward.
No, well.
So let me tell you why I'm super excited about this chat. So I thought about it very carefully. I've been wanting to come and speak to you about advice, which you would have subsequently charged me for. Whereas now, because we're on a podcast, get to ask all the advice.
Okay.
For free.
I'm leaving.
Or afterwards, you're like, so what's your company name? So I can send you that invoice.
I'll just bill Jared.
No, but on a very serious note, I mean, after our first conversation, I was like, how cool to get advice.
Yeah, no, well, you know what a nice thing is you would have gotten it for free in any case, because the consult. I mean, you know, but
I know.
we don't charge for advice, for consultations and stuff within reason, because I need to tell my clients how I can help them before I charge them. It doesn't make sense in my head, like, you know what, come pay me. And
so I can tell you.
Let me see if I can help you.
No, absolutely. I hear what you're saying.
I'll tell you what we can do. I'll look at your problem. I'll give you advice. And then if you want me to do what I told you to do, because most of the time, I mean, you know what we do, and viewers would know what we do by now, hopefully. But the nature of intellectual property law is there's only a handful of us that actually do what we do and have the competency to do what we do. Not looking down at any other attorneys or
no,
or
but
anybody.
it's niche.
It's niche.
It's niche.
I don't know how to transfer a property at all. I won't touch it.
But you know IP.
That's what a conveyancer is for.
Yeah, exactly.
So a conveyancer that doesn't know IP shouldn't advise on IP.
I completely agree.
That's the way it is. And I'm not stepping on anybody's toes. I'm just purely saying this for the sake of content. But that's the fact. So for me to tell somebody, listen here, I can help you, this is what I suggest, for them to understand, to be able to make that decision, I can't charge for that.
No.
Or thereafter, if it becomes work, yes. But
got you.
That initial part, you would have gotten for free in any case.
You.
Not just because you're a Mr. Smith. but yeah, no, it's... okay, great. So under that guise of, I'm here to have free advice. Let's do it.
No. I'm other than being that guy. No, I'm joking.
I know.
The fact of the matter is, I have a real business that I'm starting, and that I have started, and I've been running for a long time. I have a product that is perfectly suited for IP, meaning it's niche, it's mine, and we'll talk about niche and mine.
Yeah,
We'll talk about niche and mine, because in my opinion, there's no such thing as mine because everything is from other people. It's how you package it, right? It's how I put it all together. Because, I mean, I can give you reference sources for every single thing that I train. I can give you reference sources and I say, okay, for this aspect, I got it from that professor and from this doctor and from this scientist and from this business guy, you know. But it's the packaging of everything. And then there's some that's just me.
Yes.
Right? My real world business, my understanding, my experiences, you know, and all of that.
Yeah.
So let's talk about it. About 15 years ago, I got promoted to manager. Right, the title.
The title. You've got the title.
Manager.
The title and the tie.
And for whatever reason, I had some sort of self-awareness and self-actualization. And I had enough of that to turn around and go, well, I'm probably a shit manager. Right? And then this is the truth. I'm like, I'm really probably a shit manager. And it's more than 10 years ago. Gosh, I keep on saying, I've been saying 10 years for the last 6 or 7 years.
Okay, so it's been 17 years.
15 years ago.
10-ish.
But 15 years ago, I get promoted to manager and I realize, oh yeah, I'm a manager. Okay. No clue with what to actually do with that. No clue with actually how to run a team. No clue on one-on-ones. No clue on structure. No clue on meeting structure. No clue on calendar management structure. None of that. So at least I was aware enough for that. So I turn around and I say, okay, what does it take to be a manager? And so starts a 17 or 15-year-old long journey because I'm still learning and I'm still refining what it means to be a manager. But what I started doing is I started building training courses, right? And the whole idea is I want to train. But back then I was young and nobody would have taken me seriously. And until such a time as I actually get pulled into a big corporate, and now I'd stepped out of sales and I've stepped into more general management, right? And the mandate was build a mentorship program. Okay, so now because I've been working on this so hard, I have a basis, I have the information, and I have a captive audience, right? For better or for worse, I had a captive audience. So we start with this management mentorship program, and fast forward 15 years later, it's now an 8-module, right? 12-hour mechanics of success training program. Okay. And so here's the thing. Quintessentially, it's mine, but it's not mine. It's the world's. It's all this information that I've learned over the last 15 years and from all different people. So the question is, do I trademark this? Because this mechanics of success training program is mine. And so here's this complication. And this is this real world question that I've wanted to ask. And I want to add one. So number one, is it mine? Number two, it is mine. And number three, it changes. So I'm busy listening to a podcast. Very recently, I'm busy listening to a podcast and I'm listening to Andrew Huberman. Okay. And he's talking about the anterior mandibular cortex. And the anterior mandibular cortex is a place in our brain. And what this place does is it grows when we do things we don't want to do. But more importantly, it grows when we do things that, when it grows when we do hard things, but more importantly, it grows when we do things we don't want to do, allowing us the ability to do hard things. And then that is now being linked to purpose in life or your will to live. So what this says is that the more you do hard things, the more you grow and develop the will to live. How phenomenal. And in hindsight, when I say that, you're like, that makes perfect sense. The more you do hard things, the more you have this will to live because you have a sense of purpose and accomplishment and mental calluses and physical calluses, right? If it's a physical thing you're doing. So I heard about this 4 weeks ago, 5 weeks ago. I've already started integrating it into my training. Well, because
it makes sense.
It fits perfectly in what I do. And so I reference Andrew and Professor Huberman. So do you see that this thing that I have, not only is it not mine and mine, but it also grows and develops and lives. Because any good cause should grow and develop and live. Yes.
Yeah. No, well, you had a few interesting questions or key questions that you actually asked. But a main thing that the first thing that you need to understand is there's different ways of protecting. It's not just a trademark or copyright or patent or design. There's a combination.
Okay.
And depending on what your product is, or in this case, your training courses, you apply different IP aspects and IP protection methods to the business. Let's say it like that. Looking at patents. Now, patent is an invention.
Yes.
Obviously, this has lapsed years ago. But invention.
Exactly.
Whether it's chemical or mechanical or whatever, it's an invention and it's got clear rules about it needs to be novel. It needs to be novel throughout the world. Can't just be something that you change slightly and hope it gets around patentability. There's a lot of rules on patentability. You don't have patentability. It is a training course. It's not patentable. Yours specifically.
Absolutely.
Design law, that's more like this little Mario and Lego and things like that. It's aesthetical and functions because of aesthetics, but you're protecting something. You're protecting the
a
shape.
look, a brand image.
No, not nothing. We're not at brands yet.
Okay.
We're now looking at the product.
Okay.
You're either protecting a method of manufacturing or a product or a solution, but it's patentable, agreeing to the rules. Or you're protecting a design, a shape, irrespective of the brand aspect. I see something, therefore that something has a specific reason it exists, but it is that person's. They made it, they created it, or there's a reason why it is there. Cars are a good example. The shapes of cars and the shapes of bumpers and things like that. Usually you're looking at design law there, aesthetic and functional designs. Again, rules, and it needs to be protected within a specific time frame. Patents need to be protected before it becomes public. Designs, you've got a slight exclusion and a leniency on, okay, well, when was the disclosure within 6 months, stuff like that. You have to protect it. Thereafter, it's public domain.
Yes.
And I'm saying public domain for the sake of the viewers. So if there's IP attorneys listening, they're probably going to call it something else. It's just for the viewing content. Where you're looking at is more the other two aspects, trademarks and copyright. Now, trademarks is brands. That is where you protect the brand. Whether the shape, and this is where there's this overflow of certain things can be protected by more than one IP principle. The shape, Lego has or could have had a design when they first started the Lego because there's a timeline on it. Thereafter, the Lego man, the minifigure, is a protected trademark shape because you can identify a Lego minifigure a mile away.
Yes.
And they enforce it actively. Similar to Lego, the Mario here and a lot of the Marvel and DC characters, they protected, the shape of them are protected. And Coca-Cola's bottle is a shape trademark. Most identifiable shape trademark in my view, because you can see a Coke bottle broken at night on the floor and you'll know it's a Coke bottle.
Exactly.
But it's a trade.
Yeah.
Trademarks are unending. As long as you renew it and nobody attacks it, obviously, it is an indefinite right. So when you have a trademark, but it's brand, it's orientated towards your brand. So the name of your course or sub-names or key principles that you give it your own unique name. Like, this is the principle of this, and this is what we call it. That is trademark. And I'll give an example. I'll give an example in a more practical sense. If you look at a course and you convert it into a book, Harry Potter, the title Harry Potter, Philosopher's Stone, is a trademark. The characters, Harry Potter, Hermione, trademarks. The spell names, trademarks. The key identifiable elements from that is uniquely the authors, Hogwarts, the 4 schools, their names, their logos, things like that are trademarks. So it's not just the main brand, it's every identifiable reference of source, meaning I know Huntley did this. Why? Because this is his.
Okay, so
then the copyright comes.
So we could say like this, right? So let's think about it this way. And I guess de facto, I've been thinking about it this way, albeit I might not have known that. But the training course sits under the brand and under the training name Mechanics of Success.
Yes,
right?
so that's your
the
trademark.
name.
Yes.
The category that I've coined it is psychophysioergonomics. Right?
Okay.
So psycho, mind, physio, body, and ergonomics is how you apply that within a work environment. All right. So that ergo the psychophysioergonomics. So I wanted to try and categorize mine to differentiate it because otherwise it just becomes another thing.
Yeah.
And it's not just another thing, right? And then each module has a different name, right? So module 1 is meta mind. Module 2 is chaos and order.
Yes.
And so you can say I could then trademark. I could IP,
yeah.
mechanics of success. I could then do on top of that psychophysiognomics as a category, and then each one of the modules.
Yes.
And as I build those modules up,
You expand. One thing you just need to remember, and I see this quite often in industry, your trademark cannot be descriptive of the actual service, or in this case, of the training module. So you can't say, let's say, for instance, you can't say
EQ is
EQ.
EQ.
EQ
Yeah, you
is
can't
EQ.
do that. No.
So even if it's a coined phrase, if that coined phrase
a describer.
describes what you are doing, it's not trademarked. You can't trademark it. And a lot of people do this. We see this often. They come here and they've got this brilliant name, and the name doesn't exist. So there's two principles: registrability and availability.
Yes.
Availability means
just like CRPC.
Yes, somebody else has it, you can't use it.
Correct.
But we're now looking at the registrability aspect, and the registrability aspect says it cannot be descriptive
Why?
because your competitors need to describe.
I got you. So, because
You need to describe.
Yes.
How do I describe
so like
a bottle?
Yeah.
EQ.
Got you.
Everybody
uses
should
the term
do.
EQ. Got you.
Even where there's something new.
So if I said something like MetaMind, right?
Yeah,
so
that's
module one.
MetaMind.
Yeah, MetaMind. So meaning beyond.
Yeah, but
your mind.
But it doesn't describe it.
No.
It's MetaMind. It's brilliant. It alludes
So,
to it.
so,
and it's,
so
but
my
it's not,
second course is managing chaos and order.
that would be descriptive
Okay.
because chaos and order is like,
Is two different.
well, it's there. Our office is
Yes.
chaos and order. So chaos and order is a difficult registration.
Okay.
Even if we get it through,
Okay.
I'm struggling.
What
forcing
about?
it.
What about? So one of my courses is called Purpose Through Adversity, right? But hashtag anti-snowflake.
Anti-snowflake.
I'm not joking.
That is a beautiful
Right,
name.
Because because one of the courses actually
Anti-snowflake.
focuses on why society is a little bit of snowflakery today.
Yeah. Well, there you go. Anti-snowflake. That's your trademark there.
Okay.
So when you think of a trademark, a very strong trademark has nothing to do with the product, or in this case, nothing to do with the training course. MetaMind is a brilliant trademark. Obviously, we'll need to check if it's available, but registrability-wise, because if I tell you MetaMind, you're going to be like,
So hold on.
Is
So
that
it's the
the
same.
new superhero?
So it's the same as So it's the same as CIPC. You would put a name forward,
yeah.
and the registrar would come back and
So-
go, no.
So CIPC is the body that deals with intellectual property and companies.
Yes.
Companies and IP are completely removed.
No, but I'm saying it's the same.
But it's the same
Process.
principle.
So
No,
I
it's
could-
slightly different. We search beforehand. You can still file the application, and only like a year later they're going to say, "Oh, by the way, this application you filed is now refused
because of
conflicting."
registrability or
So we
conflict or
check
whatever.
beforehand. We know how to do it beforehand. Where if it's a company, you literally need to change one letter, and they'll sort of be fine with it because a company name is not.
Yes.
You don't get a monopoly through a company name.
Got you.
You can only get it through a trademark. And interesting fact, somebody can force you to change your company name if they've got a trademark. So just because you've got a company name doesn't mean you've got a monopoly. I don't need your company name or anything similar to it. But if I've got a trademark similar to it, I can force you to change your company name. Which is note to self or note to you self. So it's an important thing that a lot of people also don't understand. We've got a write-up about the difference between a company name, a trademark, and a domain name, because people also, less so than companies, but they're like, yeah, but I've got a domain.
That means nothing.
I can take your domain away from you if I have a trademark or any
Yes, because the
enforceable right.
trademark supersedes the domain.
The trademark is the ultimate monopoly.
Okay.
That's where it comes down to.
So thought so mechanics of success.
Yes.
You could trademark that.
Yes.
Okay.
Yeah, mechanics
As
of mechanics of success. If I say it's the mechanics of success, what am I referring to? Yeah, it's very close, and you understand what I'm saying. If you tell me no, it's the mechanics of success, I'm like, yes, I want to know how to be successful.
Yeah.
But you're not saying know how to be successful.
Yeah, because that's descriptive.
That's descriptive.
Gotcha.
And so it's a very nuance between where's the line. And we obviously know. I've been doing this for long enough, and I was at CIPC, at the trademarks office as an examiner. I have examined more trademarks than I think most attorneys would see in their life. In my 5 years at CIPC, we did. I'll show you when we leave. I've got a ball like that, and every trademark or bundle of trademarks were tied with a elastic band, and I just put all the elastic bands over each other, and I still have the ball to remind me. But instinctively, most trademark attorneys, proper true trademark attorneys, would be able to. You tell them a name and like, nope.
No. Yeah.
Yes,
not
nope,
gonna
not gonna fly. On the registrability side, availability searches are required unless if you tell me do Apple, I'm like, nope.
Yeah,
it's not available.
Not available. Yeah.
So that's the main thing. When you then decide, okay, well, mechanics of success, perfect. Module names. Okay, this is a module name, but let's add something unique. Let's add a identifiable, uniquely mine aspect. But so that's on the trademark, the brand side. And the nice thing is brands, you can add logos and colors and sounds. I mean, your brother, you don't know this. Your brother's voice is a sound trademark.
Makes sense. It's uniquely his.
Yeah, no, but and we keep pointing there because his brother is actually running around here,
Messing up your office.
Messing up my office. I wonder what he's doing. But he did that in the skit, and people that watch this will see it. In the beginning, there's this static logo with him saying, intellectually correct, Steyn IP.
Yes.
That is a sound trademark. We filed it as a sound trademark.
Oh, wow.
So you can do a few different versions of trademarks, smells, scents, sounds. It's anything that can identify you as you or your company as your company can be a trademark. And that's just an interesting fact that I thought I'll throw in.
It's fascinating. So now, how does it work? Okay, so now we've got so I have a product.
Yes.
And one of the products is Mechanics of Success, which is personal professional development, exec level. That's its thing, right? I have one or two other products. And then on top of it, I have the company.
Yes.
Right? And the company's Thought Lab.
Yeah, and trademark Thought Lab.
Trademark Thought Lab.
Yeah.
I mean, that came from the podcast, right? So that's why I decided to keep it. Because
it's a nice name.
We've spent so many months, myself and Jared, coming up with that name, building that name, building that brand. And so the idea was, let's bring that back into a company.
Makes sense.
And then the thought was, on top of that, carry on with the videos.
Yeah.
So that's why I do I don't know if you've seen some of my videos.
Yeah, no, I did. Yeah. I've seen a few of them. So, so Thought Lab, and just looking at a corporate structure, and I'm saying corporate, not in a employee's mindset, but a corporate, and if you look at a business, the business name must be protected.
Yes.
First and foremost, because that is what your clients will know you by. Then your product, your key overarching brand needs to be protected. And then all those subcategories. Easy way to think of it is a place that manufactures and sells products. The company has a name because that's a company. Their range of toys have a name because it's a range. And then each of the toys might have its own unique brand name. But everybody knows this is part of the entire company's product. But every time you've got a name, it needs to be registered as a trademark. And I do say needs to be because a lot of people are like, yeah, but I don't need to. Okay, you also don't need to insure your car, but you do it because that's what a trademark is. It's in case something happens, you have it. So I'm very adamant about to clients, you have to register a trademark. Because if you don't, you're basically putting something out there that anybody can just say, oh, this is a cool name. I'm going to start doing it.
So one of the reasons I'm really interested, and I'm not going to mention the client name because you and I will discuss the client name later.
We can bleep it out.
Yeah. Well, we don't need to.
No.
Exactly. So I've got a client that has approached me, and they're a training company. Okay. But they focus on product training.
Yes.
So within their subset, they are linked to a company, and their job is to train those consultants. And within that specific industry, there are very specific requirements, okay, that need to be done legislatively. And there's also very specific requirements that need to be done per department. So you can think of sales. Okay, so they need to do sales training. And you can think of client services. They need to do client services training. Right? These are just generic things I'm putting forward. Okay. What they don't have, the training company, they don't have a soft skills, and I don't like that word, but it is the right
but I know,
word.
yeah.
It is the right word. They don't have a soft skills training, right? This sort of management mentorship, this leadership program. So the company, the main company gets me in and they ask me to do training. The training company looks at my product and goes, this is great. We've always wanted something like this. We don't have something like this. Why reinvent the wheel?
Yeah.
Right? So let's potentially take your product.
Yes.
Okay. Let's potentially pay you royalties on that and use it to train.
Yes.
What the hell do I do there?
So that is...
And that's a very unique problem to me.
It's actually not.
Oh.
It's a common problem in every industry.
Okay.
Because why would you want to reinvent the wheel? Licensing is a massive part of income generation through intellectual property. We do a license agreement a week, sometimes more. It's standard. So when you're looking at that in your specific instance, copyright comes in. Yeah, I mean, like we discussed in length now, the brand, how you protect your brand, your sub-brands, things like that. Your training modules are protected through copyright. Nice thing about copyright is you don't register it. It's automatic. Trademarks, patents, designs, you have to register it. Copyright is automatic. And before you're like, oh, yes, so it's automatic. The catch comes in, you need to prove that you are the owner and the author. Now, how do I prove I am the owner and the author of the copyright in a book without using the book as proof?
Video.
Well, video, in your case, that helps. The video, the moment it's digital, it's easy. There's metadata on the back end that you can trace, stuff like that. Napkin notes, or the concept of napkin notes. Every single iteration, notes, stuff like that, just save it.
Got you.
It all
builds a case.
All builds the case of proof.
So if I was to turn around and say, okay, so here's the Mechanics of Success training program, right? Here's the videos, because I've actually recorded them, right? Because obviously we're going to turn it into a digital product. Here's all the presentations, but a lot of these things. So one or two of the courses, I have zero material in as far as I don't even have a PowerPoint slide. Because I whiteboard it. But I'd have a photo of a whiteboard.
Yes, you've got a photo
Okay,
of
I've got a photo
you've
of
got
the whiteboard.
notes of everything, and you have the research you did to remember. You don't have rights in the other author's work, but you know that.
Yes.
But you brought it together in a combination that created a new work.
Correct.
The new work, the sweat of the brow, what you put in is yours.
Yeah.
You need to be able to protect it. And in copyright side is you need to be able to prove what your effort was and when you did that effort, because copyright becomes a who was first concept. So notes, things like that, timestamps on videos, and I say timestamps, not on the video itself. It's obviously the metadata that you can't change. And that's how you then start proving
So if
the
I
copyright.
was to bring in, so let's say I'm in a copyright dispute and I turn around and say, guys, I can give you somebody who 10 years ago I trained on this specific thing.
Yes.
Right? Does that stand?
Well, if you can prove it, yes.
Yeah. Well, if I brought in 15 people and said, this is what I trained on.
Yes. Theoretically, yes. Humans proving through people intellectual property becomes complicated because I can rip it apart in court. So it's theoretically
doable,
yes,
but
it's
not
doable,
advisable.
but not ideal. What is ideal is, hey, here's a video of me
Yes.
doing this training 10 years ago.
Exactly.
Here is the slides and stuff I had 10 years ago. In your case, you do it whiteboarding, so it's difficult. Here is the training module notes I made in preparation of this.
But I have
So
how's this, right? Okay, so I'll tell you something really cool, and then we'll walk through a process, right? So about 6 years ago, I'm very disillusioned with goal setting. Okay, I've been doing goal setting for because I'm a good manager.
Yes.
For 10 years. This is 5 years ago, right? So for 10 years, I've been doing goal setting, and typically the methodology I was using was SMART, right? Specific, measurable, attainable, realistic, and time-based. And I was disillusioned with it. Because even SMART can be interpreted into so many different ways, and there isn't a methodology. And SMART doesn't stop you from setting a bad goal in the first place.
Yeah.
Okay.
And everything else is like,
Okay.
awesome,
And then-
but it's
and
a
then-
bad goal.
And then so I give SMART and I train on SMART, and then every manager goes off and does their own thing regardless. So I'm busy training with one of my clients, and I turn around to him and I said, Riney, and his name was Riney. I said, Riney, I've got a new idea. Can I run with it? And he says, do whatever you want, Hans. So on a big whiteboard at my house, a blackboard, chalkboard, I write out a formula for goal setting. Okay? Mine.
Yes.
And I write out a formula. So these are the non-negotiable things you need for goal setting. And I write it out. Boom, boom, boom. And I said, right, now this is theoretical. Let's think of these as plus. This is you need, plus this you need, plus this you need. Now let's look at this component. Let's use that as a divide by. Okay. Then let's take these last components and let's use them as multipliers. Right. So now we have our pluses. We have, and so in my mind, I thought of it as a formula. So I teach this, and he's like, Heinz, this is flipping amazing. It's the best way I've ever seen goals described ever. So I said, okay, flipping cool. I'm onto something here. So I carry on teaching it, I'm like, but hold on, let's actually turn it into a formula. So I went to Excel and I built a formula. And what you do is you put in your goals. You put in whether or not you have it correct, yes or no. You put in your rating, and then it gives you likelihood of success as a percentage ratio. And while we're busy talking, I'm thinking, I have this. So I have the photo of when I first did it on board. I have a photo of doing it subsequently. I then have the Excel spreadsheet that I've actually built and given out to people for free. Well, no, as part of my training.
Yeah, well.
But don't you think that there's a real...
Yeah, no, that's... I would be able to use all of that to prove copyright. So that's fine.
I hear what you're saying. But my question is, this goal-setting formula that I've got is very unique. And it's very specific.
I know where you're going.
And I've never seen anything like it. Never. I give it to management teams, some of which are mutual clients of ours. I give it to management teams, and they love it because it's real, tangible. What do I do about that?
The problem with formulas, and when I say formulas is in this specific case, patent law, which is the first thing most people think of when they think formulas, processes, things like that, you're going to look at patent law. Whether a formula is patentable is a question that we're going to have to discuss offline because there's a lot of variations and things that we have to look at. Formulas in this case, I'm not going to give, for the sake of this, I'm not going to say yes or no. But in general, when we look at formulas, firstly, okay, chemical formulas, it's different. It's a compound. We're not considering that. But in this case, you're saying it's a formula, but it's actually a process of determining. If I do so you converted it and yes, it's a formula, but it's actually a process. Mm-hmm. It is if I do this and that, and I add this and I do this and I do that, I have a life.
I have an outcome. Yes.
So the person that needs to do it has a process he needs to follow to have a likely outcome. That's more where we would look at if it's patentable or not. Again, I'm not saying it's patentable or not.
Yeah.
But when we look at patenting, it's that. Copyright is essentially a part of it. I would rather focus on copyright and things like that. Looking at the patentability side of the formula is what we need to do. One problem is, and remember when I said in the beginning, patents need to have a timeline, it needs to be novel, needs to be protected before it's public. You're already trained on it. So whether it's patentable or not is irrelevant. You already started training on it. Therefore, it's already in the public. Therefore, no novelty, no patent.
Okay.
So
got you.
We actually have a saying in our patent department that the office in Stellenbosch is file first.
That makes sense.
It's literally, I think it's on one of the walls, massive hashtag file first. We also have a trademark for file first if anybody wanted to steal it. But the concept of file first in patentability is essential because the moment you can destroy your own novelty, like in this case you did.
Yeah, I've exactly done that.
The moment you publish, and we had cases where we have a patent, it's a patent that's been enforced for a while, the product is amazing, we take on somebody, they come back to us like, oh, by the way, your client published this video on YouTube 2 days before the patent was filed. Great, novelty, sorry. Then we weren't aware of that YouTube video. Yes, we did our due diligence, but you can only look so far. He forgot about it. And it's like, oh yeah, I did. It's an old YouTube channel. I forgot about it. They found it because roles were reversed, we would have also started looking for it.
Yeah.
He destroyed his own novelty by 2 days posting a video of him being excited about his new product.
Okay, so fact of the matter is it's out in public domain.
It's out in the public. Copyright is where you fall back on.
Okay.
And if you have a name for the formula,
Yes, I do.
that is a trademark.
I do.
That is a trademark.
Okay.
Nice thing, because copyright is automatic, you don't need to worry about timelines. And trademarks don't have a limit. You can file a trademark for one of your brands 20 years later because it's yours. You don't have to file it before you start using.
Gotcha.
But that's the brand aspect, the trademark aspect. Ideally, you file it before you start using, or else it becomes a trademark dispute and somebody decides, oh, this is a cool name for this, I'm going to use it, and people I'm going to think I'm you, stuff like that. But a trademark, you can file any case, and the copyright you have sufficient proof of the copyright. You just listed all the aspects of it. But the patent is out of the question because novelty is gone.
It's gone.
That'll
learn me.
You know how many times we have that discussion. People come with these amazing things like, oh, this is so cool. Yeah, I started selling it last year. What do you call it? We can file a trademark.
Yeah, and the problem is, in real world, you're asset testing, right? You're building it, you're trying it. I mean, even my goal setting formula has changed.
Yes.
I've added new things in, and because, I think that's the sign of a good business.
Yeah. No. You don't. If you do the same thing over and over again for years, it's bound to fail eventually because the world and the industry changes. You need to adapt to it. Plus, you need to, in your case especially, I think to a bit in our case, but that's because I've got my own dreams in my head about my firm. But in your case especially, if you don't keep updating and developing new concepts, you're going to become irrelevant.
Yeah, or become stale.
That's the thing. So here's another thing is when you update the formula, when you make changes to it that has a substantial impact on the outcome, that's where you can start looking, okay, well, this is prior art. Can't do anything about this, but
so I
the
build
new part.
I build a formula, I change it, I update it, I morph it, I grow it by 50%. I can then...
Well, you grow it by 1%, you can, if it has a substantial impact.
Okay.
There's
So it
no
depends on
no percentage concept.
No, it's impact.
Yeah,
it's
you
impact
can
based.
change 90% of something and can't patent it because it still is exactly the same thing. Or you can change 1% of something and you can patent it because it is a new thing, or it has a new working, or it is a new application. Things like that. There's so many. When it comes to patentability and patenting, it's this vast, and that's why I've got a team of extremely smart patent attorney, and she deals with these things, and her team deals with these things. They know, I'm a brand guy. I know exactly, you can't register that. When it comes to patents, she'll be like, this is how we do it. Or that's how we do it. Or this is how we get around it. And that, again, it brings me back to that. You have to talk to the right people. And like I said in the beginning, don't go to a conveyancer about IP, and don't go to an IP attorney about your house being sold. You go to a specialist dealing with specialist aspects.
So I have a question, right? So there's another part of my business. So the first part of my business, or one of the parts of my business, personal professional development training.
Yes.
The other part of my business, and so here's a cool question I want to ask, because I really want to be able to direct people here, is I act as management consultant,
Yes.
business consultant,
Yes.
and or fractional COO, CBO, MD,
You're like an alternative
with
advisory board.
and sales.
Yeah.
No, I've got three specialities,
Yes.
right? People, business, processes. People, sales, processes. Those are the three specialities, because that's where I come from. I come from operations. I was a COO in a big group, and so that's my speciality. So I often play the role of a fractional COO, or I play the role of consultant, or I even sit on the board of certain companies in an advisory state. But I have a lot of companies that I deal with that will sit down and go, okay, Hans, I've got an idea. And I'm sure you've spoken about this, but this is something for my clients, right? I've got an idea, okay? And I have a specific client in mind that I'm not going to talk about because I'm under restraint with her, and she's a friend of mine. And so she has an idea of a product. It's a wearable product, okay? Super unique. It's super zhuzhy. It's super great. She's amazing. She's attractive. She's the type of person who could embody this thing, right? she's coming up with a name for it, right? So it's going to be
The X.
the X, correct? It's going to be called the X.
Yes.
She's busy building her logo. She's busy building her specific product. And this product will be one product with maybe 3 or 4 iterations. Wearable product, just 3 or 4 iterations. Super zhuzhy, super, I love it. I love what she wants to do. I love when she wants to do it, how she wants to do it. Your name has come up, right? Your name has literally come up. And I'm like, when you need this thing, you need to go and see Christiaan. Give her advice. What does she do?
Well, she comes see me.
Yeah.
That's
for all the other business owners. Like,
but for all the other business owners.
What step?
The first step, and I always say, we actually get queries like this quite often. We tell them, tell us the product.
Yeah.
We need to know what it is because we need, like we just said, there's different IP. How do we protect it? And obviously it's confidential. Dealing with us as attorneys, it's worse than an NDA. We are bound by law to be confidential, which I like. It's not worse. It's better. So what I would tell her is take wearable concept in mind. Okay, well, the name we need to protect. If your product is novel, if there is any chance of us being able to look at patentability, do not disclose this to anybody. Before I give you a confidentiality document, not an NDA, don't download an NDA, that doesn't help. I need to protect the novelty. It's a very specific NDA we give you, or the client, to protect the novelty. Where she then needs to go discuss it with third parties, she doesn't destroy her novelty. So that's the one thing. If there's anything like that.
Now, what a perfect third party can be, and I mean, I actually know what's going on in this specific product, right? Is she's currently busy speaking to a manufacturer to develop the product. And, and it hasn't been developed. It is busy being developed. So they're looking at design, they're looking at cuts, they're looking at material, they're busy with that right now.
Yeah.
So you're saying
they need to get a document. Pause. Talk to us, get a document in place, go on.
Then go on.
Yes.
Okay, so now...
Or there might already be a document in place without them knowing. There might be a SLA agreement, something between them.
No, there probably wouldn't be.
Then pause. Pause. Talk to us.
There's another thing.
Yeah.
So my specific client, she has her own business, and her own business is it doesn't matter in a specific industry. This is a side hustle for her.
Yes.
Right. And so we've brainstormed it, and I love the idea. And I think she loves the idea, and I think it's a good product. I think it's a good marketing strategy. I think she's the right person for it. But the budgeting now is a hell of a thing because this is a side hustle. This is a little thing. So in my mind, I'm just going to go. I'm going to go do what I have to do. Go to the manufacturer, start building the website, start building focus my budget.
Focus on getting into the market.
On a domain. Right? Focus on the website. Focus on the product. Focus on all these types of things, and so I'm asking out of pure interest sake. I'm gonna send her to you.
Yeah.
And what happens there?
Well, if she when she comes to us, we literally have this discussion. Basically, what we're having now, we're obviously having a lengthy one now, but we ask her to share stuff with us. We look at it. We give her advice on what to look at. We tell her how we would propose what, if there's patentability, this is what we look at, this is what the costs are, trademarks, these are what we propose on your brand aspect because there's different classes and elements that you can protect. This is the cost, this is the NDAs. Basically, we give her a proposal based on this is your IP, this is how we protect it, or like the Rolls-Royce aspect. But let's work with you to see where does it make financial and strategic sense. Yes, you can file a patent, arguably, but it's going to cost you more than you'll make back. Why file a patent?
Agreed.
Don't file a patent, and I'm very adamant about it in my firm. Don't file a patent if you're not going to make the money back of the cost of the patent. It doesn't make sense.
Agreed. And patents
are expensive. It's one of the most expensive IP registrations. Trademarks are the least expensive, subject barring copyright that doesn't cost you anything. And again, I'm talking in my firm, not referring to
copyright doesn't cost.
Yeah, because you don't register. When you enforce, yes.
Got you.
Because you need to go to court to enforce.
Got you. So copyright free.
Copyright is free. You must just understand how to do it. Trademarks, not expensive.
what is?
Well, but with us, you're looking, and please note the date here because it might change in years.
Yeah, you got it. So
Currently,
somebody comes up to you, it's like,
hey, what is this? It's like, no, that's 10 years old. I still had hair there. Look at hair. So today, on the 28th, 27th
yeah,
of
February,
2025, financial year in 2025, we charge 4,190 Rand, excluding VAT, for a trademark application. I know. What?
Oh, wow.
It's so cheap. I just embraced your brothers.
Yeah.
It's that's us.
So
you
would
get
that
cheaper. You get cheaper. Don't get me wrong, and you get way more expensive. I know what we offer for our price is an extremely good price for everything it includes, because that is what you will get the invoice for trade.
And would that be per trademark?
Yes.
Okay, so Thought Lab, trademark.
Yes.
Mechanics of Success,
Second one.
trademark.
Yes.
And then modules.
Depending on how many you have.
Yes.
Obviously, the moment you've got 5 trademarks or 10 trademarks, I'm not going to say times 10. I'm going to say times 10 less this percent.
Okay. Perfect.
Plus, you're a family friend, so it's got to be less.
No, but I'm trying to paint the
yeah.
picture for my client.
No, it's
because I'm
you're going to yes,
well.
you're going to
and so I could turn around and I can go, okay, cool, Christiaan, this month I want to file for Thought Lab.
Yes.
As a trademark.
You've got, and
in 3 months, or I say to you, actually, Mechanics of Success
is more important
than Thought Lab.
That's what my advice would have been in any case.
I would have thought,
you're
right?
selling Mechanics of Success.
So let me trademark Mechanics of Success, right? Then let me trademark Thought Lab, which covers, and then slowly
start looking at
rolling it out because a small business owner and a mid-year business owner, I'm going to spend 50 grand on it.
No, I mean, and we do this often for all our clients, big or small. And I mean, the clients we've got. We've got
clients we've got, yes.
Small musicians that file one trademark in their life, and we've got multinational fueling companies that file
we actually,
thousands of
we actually have a shared client.
Yes, we do.
King Price.
Yes, hi King Price. I should have fitted bobblehead here.
I do,
But so depending on the client, but in all of them, we approach it the same. We do a review, or we call it a review, but that check about here's what we can do. We sit with the client, we give our advice, considering what you are doing, considering what we looked at, how you are putting it into the market. Here's everything you can do. However, we suggest you start with this.
Yes.
And then we sit and say, okay, well, strategically and budget-wise, what fits you? File one a month, file one a year, file one every 10 years.
Doesn't matter as long as you file.
We are essentially in-house for that. We walk this road with you, how long ever it is, to make sure that this makes sense on the trademark side.
Got you.
Patent side, time constraints, that's obviously, but we also say, you've got a patent. This is the cost of a patent. Anything from 15 to 40,000 Rand, depending on the complexity, whether it's a provisional or not. Now only talking South Africa, we can file internationally, other countries, different costing aspect there because it's foreign costs. But do you want to go international? Yes or no? This is how we approach international.
Of course.
Do you have a design?
So my first trademark, right, of Mechanics of Success, when we file it, do we file it South Africa or world?
So you can't file a world trademark. You don't get a thing like an international.
Okay.
You
so
say, where do you want South Africa?
Then I say, I'm going to go to the UK.
Then we file
Then we go to the UK. Then I say, all right, now I'm going to get a client in Australia. Then we go
file
to Australia.
Yes. At least when you know you want to start trading there, start looking at it.
So here's something interesting. Let me throw back, because I think a lot of people would sit in this space. So one of my business models is to be able to train in real life, right? It's my primary business model because I can effect the most amount of change, right? But now what happens is I sit with you. So let's say you're a manager in one of the businesses I'm training, and I train you and I run through everything, and you're like, Huntley, this is absolutely fucking mind-blowing, which it is. And you're like, I wish my wife could do this as well.
Yes.
And that's the most common thing I get. I wish my husband could do it. I wish my brother could do it, right? And because I'm working with a big organization, that's not possible.
Yeah.
So the thought process is, let's record everything, which I've done, right? Let's take that and create the product.
Yes.
Right? And where I'm training, if they want their loved ones or family, or they can do it as well.
Yeah.
So I'm going to put this on my website, okay? Or I'm gonna put it on my website. I'm gonna create a Moodle, or I'm gonna go to Udemy, or whatever the case may be. But I put it out into public space, and I have a trademark, right, for that. Let's say I've already got a trademark in South Africa, but now somebody's watching it from the States.
Okay, so they're not. remember copyright. The copyright you'll be able to enforce in the state.
So that's under the copyright.
For them, so they won't be able to botch. If they botch your product, if they relist it somewhere under there, then you have got a copyright claim. If they are ever going to states like, we have our own training module, but we're just going to call it what you call yours.
Yes.
There are ways sometimes we can take that on because there's a common law principle. If you can prove you have a reputation in the States and you file your trademark, there's an argument you can make about, no, but I have the prior right. Difficult argument, but there is this opportunity. But, I mean, you have to prove significant reputation. But there's this little loophole called convention priority claims, which means if I file in South Africa today, I've got 6 months to file anywhere else in the world, and I'll still get today's date in that country.
Oh, like backdating.
Backdating, essentially backdating.
Yeah.
Convention priority.
See the non-lawyer guy just using normal
backdating.
words.
I'm going to start using backdating.
Backdating.
I'm like, why didn't I think it's backdating?
Yeah, I'm a business guy. I'm not a lawyer.
It's backdating.
Okay.
So within 6 months of filing one trademark in one of the convention countries, which is the majority of the functioning world, I'm now probably stepping on toes of somebody that's in the functioning world that's not convention, but most of the countries where you would look at, you would file South Africa, argument's sake, cheapest, local, let's do it. And then within 6 months, you can be like, okay, I want to go to the EU. Nice thing about EU, it's a group, so you file an EU application. You can still file individually in each country, and then you're like...
European Union?
European Union.
UK separate.
Yes, because now UK separate. Used to be part, now it's separate. Yeah. Okay, I want to go to UK, Australia, USA, European Union.
So would that be a separate one?
It's going to be separate.
5.5.
It's 4.5 in South Africa.
Of course, it would be.
It depends on what it's there. I know more or less what costs are there, but I'm not even going to state it here. But it depends on which of those countries. And we also, if you say, no, well, I want to file in America, I'm going to like, this is what it's going to cost you in rands.
Yeah.
So.
And that's a problem.
Yeah. So if I tell you now and tomorrow it's different, I would tell people, okay, guys, no, this is the US expense and everything. My rand value, my service fee is fixed. It's a rand service fee. That's what it's going to cost you for me. And these are the additional costs. Our foreign agent fee is X. The filing application fee is Y. This is that. So that you know what it's going to cost. I don't believe in hiding fees. It's the easiest way to lose a client is, hey, I'm going to charge you 4,000 Rand for a trademark. And then the invoice has 5 other things that you didn't know of.
And unfortunately,
that's your fee.
Law is synonymous
with
hidden fees.
We're trying to fix that. With us, you don't get that.
Yeah, it's straight up done and dusted.
This is 4190 excluding VAT for the application, and it includes everything. Yeah. All the hidden fees and stuff is part of that. It's there.
I've got you.
That's what the invoice is going to say. If you file 2, it's going to be like 2 times. But what happens, I'm glad you raised this. What happens is he's checking. Okay, cool. I actually one day want to put a camera here so that people can see Jared, Jared doing his thing behind the cameras. And I'm like, what? So remember when I said there's people cheaper than us? A lot of them don't. The hidden fees are not there. So they're like, oh, wait, but I can file there for $1,000 cheaper than you. I'm like, okay, phone me when you get an invoice. And then if I'm, oh, this is more. I'm like, yes, because
hidden fees.
I tell you, this is including the filing fees, including the postages and pays, including the admin fee on FICAing you as a client, opening the file, all of that. That is the fee.
Of course, yes.
You will get where okay, great, it's less for the trademark, but opening a file, having the consultation, sending an email, answering an email.
All part of the concept.
We don't do that.
So yeah, because that's separate fee.
Yeah, so
now I've got you as my IP lawyer.
Yes.
And you filed for that. So the deposit here, create an invoice.
Yes.
And I've got 4.5 grand for Fort Lab. I've got 4.5 grand for Mechanical Success training program, which is absolutely amazing. And now I turn around to you and go, listen, dude, I need a service level agreement or
Yes.
contract agreement
Yes.
with my client just for services.
Yeah.
Can I come to you as well?
Yes. So everything relating to the business law aspect, we can do.
Okay.
I don't do it myself. I believe in using people that can do the
Your
job.
your group can do it.
Yeah, our group, the firm can do it. And we've got very competent people specializing in various aspects. But yeah, great. You've got a SLA you need. Okay, I'll give you one. But I'll give you a specific one that you can reuse, because why are you going to pay me 3 times for the same agreement by me just changing the name? So I'm going to give you a
And the reason I
generic
ask
one.
SLAs is because SLAs is so
It's
important.
standard,
It's
yeah.
one of the standard things in services and that. So service level agreement would be a very standard
Yes.
thing. Okay, so I come to you now. You've sorted out a trademark. I've asked you to do a service level agreement for me. What does the costing on a service level agreement look like?
That depends on the what you need. And this is, again, why we don't charge for consultation. Of
course.
You want a SLA?
Give me a
guesstimate.
Give me a guesstimate. Give me a guesstimate.
Anything from
I hope you see I'm budgeting.
Yeah, anything from 3,000 to 30,000,
Okay.
depending
On the complexity.
SLA can be 4 pages.
Yeah.
SLA can be 40 pages.
So let's use this as an example. And again, I'm hoping guys that are looking at this can go, okay, I see. So I do management consulting.
Yes.
Right. The service, I don't believe I need a service agreement for my product because at all.
It's not.
But on the management consulting,
You do.
I need a couple of things, and I need 3 or 4 pages, if that. Right. It's what is my obligation to the business, right? What are my hours to the business? What are my hours not to the business, right? What does invoicing look like? I'm assuming that I would put in there something along the lines of protecting the client in terms of their IP.
Liability, intellectual property, dispute resolution, term of the clause, term of the agreement, exit clauses.
And that could be month to month, the 30-day. And so we will draw up something a little
Payment
bit
terms,
androgynous.
yeah.
A little bit of androgynous. So the androgynous side means that I can just fill in 30 days with a 30-day notice period, or 6 months with a 30-day notice period. So we can just fill that in. So something super small, something super easy,
Very
not
basic.
complicated.
Probably about 5K, 5 grand. More. Don't hold me to this.
No.
But that's why I said don't hold me to this. But when, and don't hold me to this. If somebody comes in like, hey, you said 5K. No, it's essential. And the consultation is why it's so important. And again, why it doesn't make sense charging you for a consultation.
Of course.
We sit, you tell me what you want. I know what it is. And I say, okay, great. This is going to cost you this much. Are you happy with me to proceed? Yes. Wonderful. There you go. If it takes me longer, it's my fault. I already quoted you.
Can you also do CIPC registration?
Oh, yeah. But I don't like company registration. I can for a company. I always tell my clients, use your accountant. Why? Because he's going to need to file annual returns and ultimate beneficial ownership. So I registered and he's going to take it over in any case.
Got you. So rather like,
but I can. I do it for a lot of my clients.
You see, and again, so where is this coming from? As a consultant, I sit with medium businesses, small businesses, and sometimes very large businesses. But the very large businesses don't play in this space.
High King Price again.
King Price doesn't play in this space. But my smaller medium clients would turn around and go, okay, Hans, how do I get the best value for my money? And then I'm like, okay, so you're using me, and that's great because it's far cheaper to have a fractional COO than to pay my salary. You're using Steyn, right? IP. You're using, okay, so now what else do you need? Do you have a proper accountant? No. Okay, perfect.
Yeah, here's the guys we
here's
suggest.
the guys I use, right? And you can use them for 1, 2, 3. All right, perfect. What else do you need? Okay, so what are you doing on payroll? Or what are you doing on HR? Okay, so then there's the HR component. Because these things are typically the things that small, medium business owners don't look at.
No, they don't.
They don't look at HR.
They just want to do their
Correct.
business. Yes.
No, and it's a fucking pain in the ass.
Yeah.
It's a pain in the ass paying payroll.
Yeah.
Right? It is.
But you don't have to do it yourself.
No, you don't.
That's the one thing. I mean,
well, now it's getting that.
Yeah, it's,
I mean, your barrier to entry to opening a business is so much easier now. And despite that being said, it's still fucking.
No, it is. I mean, we are relatively bigger, small firm, if I could put it like that.
Yes.
I don't do my own payroll. We outsource it.
Yeah, of course you do.
Because
I outsource it.
We've got a brilliant accounting team that's outsourced because they know what they're doing. I don't need to pay their salaries permanently. And they specialize in it.
Yeah, exactly. I mean, I do exactly the same thing.
It makes sense, and I believe in it.
What tech are you using?
Ooh,
What tech are you using?
Well,
Because
there's a few. There's a few I'm not gonna. I'll mention to you
okay, so
afterwards.
there's one- okay.
But
what will you mention? So and I'll tell you. Yeah, what are you using?
so tech wise, like platform wise.
Yeah, what tech are you using to try and minimize costs to your business
Well,
and maximize efficiency?
yeah. Well, to us, obviously, I know our AI.
Oh yes, you've got your own AI.
Got our AI
Who identified as a woman.
who identified herself as a woman, which is the most amazing thing, and taught herself Afrikaans, which is
right.
by just listening to us.
So you have Ino.
We've got Ino, and what Ino does is it eliminates that mundane. Hi, what's a trademark? Those time wasting
So
questions.
hold on, is Ino like a WhatsApp bot?
It functions. Part of Ino functions as a chatbot.
Okay.
On our website.
Yes,
if you go on our website,
And you can just ask.
you
any
can
question.
ask, yes, and not any question. Don't ask her about Hitler.
Don't ask about JFK assassination.
No.
But you could ask IP questions.
You can ask
That's
IP
pretty
and
fucking
business
cool, dude.
related questions, and she was trained by us. It's an internal trained bot, so it's not.
So you just,
Yeah, it's not ChatGTP. It is South African law based. So we've got Ino. That's a quick aspect. There's on the back end other things about Ino which I'm very excited about, but I'll tell about that. So we've got that. We've got a lot of management tools, and I mean the traditional software management, time management tools like that. Open source, free
What are you
tools.
using?
Geez, you're going to have to ask our tech guys for that.
Okay.
I know the ones we use on. We've got so we've got a file management software that used to be called. I think they called it App for Legal, but it was bought over by a few people. So we've got that, and we integrated with a few things we had developed ourselves internally to help us streamline certain things. We're actually launching something new next month, but there's a lot of developments and apps. I say apps, but solutions we had developed. I actually think you know some of the developers because I know Jared mentioned that you guys are chatted to one of them, but so we've got file management software. We've got accounting integration from Sage. I mean, accounting software is accounting software, but we were able to integrate it in the back end on a few.
So maybe something we can mention here is Francois' software.
Yes, that's the one I was talking.
Okay.
So Francois, from they call it my subscription. Sometimes it's not.
So
but they drafted
my
a few.
subscriptions
It's an amazing thing.
Next level,
I
and
know.
I can't stop talking about
I
my
know.
subscription.
And some of the integrations, some of the platforms we have, they built for us. They use their standard software as a base, but they modified the heck out of it to make it work for our needs. One thing you have to remember about our office is there's no paper. We are completely paperless.
Nice.
So having the ability to have that integration is amazing.
Use Microsoft.
Yeah,
365.
we use Microsoft 365, so our files are SharePoint based.
Yes, SharePoint based, and using Teams. I use Google Workspace.
Yeah.
I'm a Google guy.
It's the same thing.
Yeah, same thing. But
Yeah.
but again, I think barrier to entry, my opinion, barrier to entry for a new business owner, right, is I take my domain,
Yeah.
I give it to my service provider, they ingest it into Google,
Yeah.
I open up and I have absolutely everything. I have documents, and Sheets is better than Excel. I truly believe that, right? And I'm a super user, right?
Yes.
Sheets is better than Excel. You've got Google Meet, you've got your jar, you've got permission.
Yeah, you've
and
got
the
all
thing
of
is,
that.
I can set all of this myself.
Yeah.
And whereas the moment Microsoft comes into play,
You know,
it gets
I
a little bit
understand that.
complicated.
And this is again, it's something that it's like the Samsung, Apple.
Of course.
It's partly a personal preference, but partly also what your business needs are. Because to us, Microsoft was essential. A lot of the third-party applications we have to make use of needs to work with Microsoft.
Yeah.
Plus, I started as a one-man show, but the intention was from day one to grow. I didn't start and see where I'm going. I came in with a proper mindset about, I want these attorneys. I named them on my list by name. I want to get this attorney, that attorney. Microsoft was the ideal one.
No, it makes perfect sense.
But Google
you're
makes
off the back
sense.
of you're off the back of somebody who's using Microsoft correctly, using the cloud correctly. All your data is backed up, has to be GDPR, POPIA, etc.
Yes, yeah.
And mine doesn't have to be, but it's the ethical thing to do.
The ethical thing.
Most business owners I know, small business owners I know, right, are running documents.
Yeah.
on the laptop, right? And I'm being very serious.
No.
So that's why I'm asking about all these different things, like just slicky things that young business owners can look at. And so Google Workspace is great.
Yeah.
AI, which AI tools are you using?
Well,
just typically.
Our AI was...
Other than yours?
No, we use ours.
Okay, so you only use...
But remember, ours was written to be able to tap into some existing AI.
Gotcha.
Remember, the other thing is we don't like using AI in law because we have an obligation to make sure that things are right.
Of course.
Don't get me wrong, there's certain things where AI is amazing. I love AI.
And the other thing is...
I love AI. But in law, the limitations on what, how, and where you can use AI is more. So there's still this ethical obligation on us as lawyers where it's, okay, AI would make this easier, but I'm not going to use it because I need to make 100% sure that even the paid for versions of ChatGPT and all of those things, I still have the obligation on it. So there's places where you can use AI.
Makes sense.
Law, in my view, especially something as stringent as what we do, you have to be very cautious of using AI. Not because, yes, it makes stuff easier. If I could use AI for everything, I would.
You could be lazy.
I would be lazy.
Yeah.
But in our industry, that's a absolute taboo. You will get in so much trouble if you draft.
Got you.
If you draft a court document with AI, you'll be debarred if they find it out.
Yeah, and rightfully so.
Rightfully so. So that's why, and I say this for two reasons. If you use us, you're not going to get an AI answer. But also, to the lawyers, and most of the lawyers know that, and hopefully, and I'm junior attorneys, candidate attorneys, be very, very aware of using AI because you've got this obligation on you as a lawyer. It's just one of those things.
Yeah.
But for the clients out there, the business owners, use AI wherever you can because it saves so much time.
I'm using ChatGPT.
Yes.
And Professional is unbelievable.
Yeah, no, Professional
right?
is
And then
amazing. I've got it for my personal use. I do.
WhatsApp Business, we're starting with WhatsApp Business. And just as a side note, Claude.
Yes.
So Claude I use for copywriting.
Okay.
So Claude.ai, that really, really good on Seth Godin.
Yes.
I'm the author, Seth Godin. He says, and then I've started with DeepSeek. Just to see, because they've made such a stink, right?
Just do yourself a favor and ask DeepSeek what it is. Because I heard a rumor that if you ask DeepSeek basically a question about what are you, they answer themselves as if they think they ChatGPT.
Really?
I've never tested it, but I've heard. I'm like, yeah. So DeepSeek and a lot of various platforms. I heard this rumor where it's DeepSeek thinks it's ChatGPT sometimes.
What are you? Oh, no network error because I've got flight mode on. Because I'm a good podcast guest.
But check it afterwards.
I'm
not saying it's true.
I want to see. I want to see what it says.
Have DeepSeek, but I think it's brilliant. DeepSeek, the ability that DeepSeek did, they gave a massive AI platform at a fraction of the cost. Their overheads and stuff are minimal compared to OpenAI.
Correct.
So I know DeepSeek and I know the business. I've looked at it and it's amazing. And obviously, I'm curious about the intellectual property aspect where the fights will start, because eventually it will start. And there's so many AI.
Well, I mean,
video creation and content creation. There's so many. One thing I do always tell people, use AI. Firstly, use it in the correct manner. And secondly, don't try and give your work forward as AI generated.
Yes. So I want to jump on the back of that. And I was training this morning. And I got asked to put together a list of items. So I was training this morning and I said to them, okay, so I used AI to build this.
Yes.
But let me explain to you my process on how I did AI.
The prompt.
So I sat down and I wrote a 30-minute prompt.
Yes.
30 minutes.
No, but
and I dictate my prompts.
Yeah.
Right. So I'm dictating. So I dictate into notes.
Yeah.
Right. Apple's dictating is unbelievable.
Beautiful.
I'll give you a hack now. I do for books, right?
Okay.
But I'm dictating into notes, dictating this whole thing down. Open up that data on cloud, pull it out of notes, copy it in, right? And it includes like this. This is what I'm looking for. Here are 20 examples. This is the author that I'd like you to refer to, Andrew Huberman, Jordan B. Peterson, Peter Attia, Rhonda Patrick. These are the books that they've written that I want you to refer to. Here are another 10 examples, and that is a prompt.
Yeah.
And you give that into AI, and then it gives you gold. But most people
Or
so lazy.
write
me a thing. And that's so, and I can spot AI.
Oh yeah, same.
I can spot AI almost
a mile away,
and I
same.
judge the fuck out of you. So don't dare use AI flippantly. So my hack.
Yes.
Can I give you my hack?
Yes.
I listen to audiobooks.
Yes.
Okay. I'm an audiobook fanatic. So if you're listening to, I use Audible. So I have tokens, and every single month I'll purchase my book on Audible, and so I'll have my Audible open. So now here's the thing. For those of us who listen while we drive, how do you take notes? So I have notes open, I have my audio playing, and the transcribing on notes in iPhone is next level. As I press transcribe, it automatically pauses. I talk my notes in, I stop, and it carries on playing. And that's my hack.
That's cool.
How cool is that?
That's amazing.
Yeah, and I do that
Oh.
all the time. I've started transcribing everything. The other day, I had a policy to you, right? So one of my clients gave me a hard copy policy, right? So I'm looking at this policy, and we need to make changes. So just out of interest sake, I needed to add in vaping to smoking.
Yes.
Right? So the policy for smoking is already there. It's been written by the HR team. So now I just need to add in vaping. So we also needed to understand that we needed to allow the client to have the smoking policy at their offices and at their clients, because they go and see their clients. So we needed to add in this portion as well to go, okay, you have to adhere to the client's smoking policy. And in the light of knowing what that is, the de facto is don't
smoke.
Okay, so I handwrite this in. So here and I sit, myself and the owneress, we sit and we write our notes in, and she gives notes and I give notes. And then we couldn't find the soft copy. So now I got a policy in front of me, no soft copy. I opened up notes and I just started transcribing. And I spoke the policy.
You read it essentially.
You read it with all the changes.
Yes.
It came up. It was 95% accurate.
Yeah, you just need to add to
reviewed it.
Yes.
Made sure it was right. Done.
review it.
Oh, I reviewed it. Of course.
That's how I didn't think. No. The one thing is, if you use AI, review it.
No.
Review it.
So
Z instead of S.
Z&S,
Favor instead of favor.
So you do your ChatGPT prompt. You do everything you need to. So I would even take that, then stick it into ChatGPT and say, check spelling and grammar.
Yeah.
And make it UK.
ChatGPT is amazing for that.
Spelling and grammar.
Spelling and grammar, convert to UK.
Claude AI as well.
That's
my last use for AI.
We actually in the office, the one place where we are allowed to openly use ChatGPT is before you send something out, make sure it is grammatically correct and UK English. And then we draft the document, you put it in there for it to check.
I couldn't agree more.
And you compare the two. You don't copy and no, you compare. Oh yes, there you go. And we've got very cool tools that do comparison of documents because we use it in.
You need to.
I mean,
versioning.
Yes. No, but the versioning is one. But if you go and copyright again, here's their version, here's the copied version. I'm not going to read word.
Stick it in,
and it gives compare, and it gives highlighted comparisons. Here's the change, here's the grammar. Because some people,
what tools are you using?
That's confidential.
Okay.
Yeah, unfortunately.
Can you tell me afterwards?
I can tell you afterwards.
Okay, deal. I need to know this in my life.
It's a legal tool. It's a slightly expensive legal tool, but it does that, and it's very effective where you can easily compare, and it also checks variations. So not just I rewrote this. No. Checks concepts, and it's a very in litigation. We use it mainly in litigation, but it has this nice feature of somebody made changes to a contract without using track changes. Just use that; it will show you where. I know it will show. That's why.
For shame.
That's the one reason why I prefer not giving my clients Word documents. because
somebody's going to.
some got to,
No, you
not
have
not
to- you have to-
necessarily the client, but somewhere somebody
You have to- and
yes,
besides, you can give it in PDF and you can
they
make
can make
notes.
notes. That's what I'm like. Just do the notes on PDF.
Exactly.
We will change and send you the changed version, because the risk of, and if somebody insists to me, no, but I want it in Word, then I tell them I cannot guarantee that the final document will be the document I gave you.
Yeah.
Be
How?
aware.
Yeah. How?
Yeah, here is the PDF version of the final document. Here's a Word version. I wash my hands.
And let me give you an example
In the Word
of
version.
how this can go wrong. This guy opens up this document, and let's say it's on SharePoint. Somebody else has access to that. They open it up at the same time. They put something down on a keyboard.
Exactly, and we've seen it before.
Yeah, I've seen that before, and it's not even.
Wait, but this word doesn't make sense. I'm just going to rewrite it into. I asked ChatGPT what this word means. I put a normal English word in. You just change the bloody agreement.
Especially if it's legal.
Legal is legal. Sometimes it does not need to make sense. It is law. it's law.
Dude, that is so bad.
Law is one of the, and look, and I mean we'll wrap up now, but one thing I try and explain. I'm married to an attorney, so luckily in our house it's easy. But to a lot of people, it's law is black and white. It is the law. 90% of business, 90% of society is negotiable. Law isn't. Now, then, so the nature is, okay, this is what the law says. Yes, but can we not? No, this is the law. But most people don't view it like that, because that's society. Everywhere else, you can find ways around that. Law is law. And that's why we don't want to give people a Word version, because
Perfect sense.
to you in society, which I completely agree with,
Ambiguity is okay.
ambiguity is okay.
Yeah,
The moment it's legal, where you put the comma makes a difference may make a difference on interpretation. And that is what a concern is. So going back to your question about what, if you go to a client, this is what you have to look at. First thing is talk to an intellectual property attorney before you start. That's sort of the first thing. And like you now know, talking to us doesn't cost your client money, so just do it. Then your brand needs to be protected. Even before you register a company, the trademark is more important, because that's the enforceable aspect. If you have anything that you have developed that might be patentable, that you feel, no, this is unique, talk to an attorney before you do anything on that, so that we can either see if it's patentable or not, but at the very least, give you the confidentiality documents you need to be able to chat to third parties about this. Do not post anything online if you think it's protectable, because it destroys its own, and trying to delete it afterwards doesn't count. I had no way to find things that have been deleted years ago, because nothing is deleted. It's just archive.
It's frightening.
Way back when engines are amazing.
Yes, I was just about to say the way back when machine.
And it's the way back when machine is only one of the engines.
Okay.
Way back when machine has every 3 or 6 months. We have platforms and stuff we use that can go into hours. I think they changed from this hour. Cook, there you go. This is where they changed. Oh, by the way, this coincides but with the time and date we sent them the letter of demand. So thank you for showing you are aware of it. I mean, that's
Causality.
Trying to hide something on the internet is almost impossible to people like us. Well, like my team. We've got white hat hackers that will be able to trace things that sometimes scares me. And most law firms do that. Most IP law firms have that abilities. And we call them white hat hackers. They call them something else, but it's at the end of the day, they know how to trace. Then sit and strategize. Budget for your intellectual property.
Yes. I think that's...
Annual budget should include the intellectual property proportionate to your business. Because you're gonna have to enforce eventually. It's gonna cost you money. You're gonna have to expand on intellectual property. You might want to go international. Budget accordingly, and we can assist you with that budget considerations. We sit with a lot of people's accountants, like, okay, this is how we need to do it. How we need to value your IP if there's a merger and acquisition, things like that. And then you have this base level about, okay, wait, now I can start. do not try and do this and try and get IP afterwards, because remember I mentioned the car and the insurance concept. A lot of people put IP and the contracts and the legal stuff aside because I'll deal with it later. That's similar to not insuring your bloody brand new Ferrari and then trying to, oh great, the taxi bumped into me, I'm trying to get it insured now. No, that's not how it works. If somebody infringes your IP and it's not protected, it's too late. That's where it comes down to. And we've seen that also a few times where people come to us after we sat and sent them the proposal and they're like, no, we'll do it later. And then they come to us, oh, somebody stole it.
Too late.
No, they didn't steal it because it didn't exist. It wasn't registered.
Oh, so
They
it's not there.
copied it, but they didn't infringe your trademark because you do not have a trademark. Because there's no registration. And that's what any business, whether you're big or small, this essential thing is don't underestimate the value and importance of your intellectual property. First thing, that is from my side the most important thing is, and then because of that, just chat to us. We'll guide you, and we're not going to charge you to guide you in the beginning. It's so easy. Just oh, by the way, how do we do that? And reaching us is so easy. And then when they talk to people like you obviously, I mean, you've mentioned us to a lot of your clients. We know, and we thank you for that. But you would know, okay, guys, remember, you've got this new concept. Let's just pause here and make sure everything is.
And that was cool for me for today, to also understand that and to be able to advise my clients correctly and go, okay,
just whoa.
Historically, this hasn't been something that is on the A list.
Yeah.
But at $4,500, it can be on the A list.
Yeah. You know what? It's probably as cheap as registering a company through an accountant.
Yeah.
Maybe some of them are cheaper than that. I'm not saying they are, but it's
same thing.
It's like, there you go. And it's a 10-year right that you renew every 10 years and it goes on forever as long as you renew it. Look, think of it like this. We're getting a time. Think of it like this. 4,190 Rand. Maybe a year later, there's another 1,000 Rand that might be payable for publication and things like that. We disclosed this to our client beforehand. And then you've got 10 years. So divide that by 10. That's what it's going to cost you. So it's insanely important.
Thank you for your time, bro.
It is amazing.
Much appreciated. I have enjoyed this.
Yes.
I've enjoyed this because I like picking people's brains.
Yeah, I know.
Yeah. Who was the podcaster here? And the podcast team.
I have to say, this is the first time I've spoken less than my guest.
I have questions for my clients.
No,
for me.
I love it. And most people that watched it, there you go. That's the alarm. We're done. Most people that watch this would know. I'm like going. This is the first time I've sitting here. I'm like, okay.
Asking some questions.
Yeah. So no, I've enjoyed this. Thank you.
Love it. Thank you, bro.
I will chat to you again. And I think that's a cut.
Dude.
This was fun.